Public Participation Act that was later heard by the trial court. That motion was filed on June the 12th. A summary judgment had been filed prior to that pending, therefore preventing non-suit, leaving it in a procedural posture where the hearing was heard on June the 30th. An order granting the petitioner defendant's motion was entered July the 11th, which is, the court is aware, is interlocutory in nature. So therefore, we don't appeal the grant of that. I think that issue probably was waived. The court at that time awarded mandatory attorney fees, reserved the ruling as to the reasonableness of those fees, and whether or not there would be sanctions awarded. Ultimately, the trial court entered some orders piecemeal, one denying a Rule 54 motion on the plaintiff appellant's trial counsel, and the other one granting the reasonableness of the attorney fees. On December 4th, the court laid down an order granting sanctions against the appellant in the amount of $100,000. We're here on appeal of that award of attorney's fees for several different reasons.
Wait a minute, the award of attorney's fees or sanctions?
Yes, sir, sanctions.
Sanctions, okay.
Yes, sir. So we're appealing the sanctions order laid down on December the 4th, based on the fact that, one, the court borrowed language. Well, first off, in its analysis, it started that there were 33 states that had a Public Participation Act, narrowing that then down to 2 states that would allow the litigant to be sanctioned. In that state, they did some analysis under Kansas law and then pivoted to Texas and borrowed the Texas land use factors, as we don't have a test yet for this that I'm aware of. Interestingly enough, in this case, there was never any proof. There was never any testimony taken. The only thing that I could glean from the record was that there was an affidavit attached to the petition itself, which was a Rule 12 motion / petition, and in my brief I refer to it as a motion / petition, that Mr. Rosenberg had reviewed some materials. Well, these were never questioned. They were never up for interpretation. I'm sorry.
So when did your client request an evidentiary hearing in this case?
Well, the client never the trial counsel never requested an evidentiary hearing. But what we're arguing here is that when the court levied this sanction in a punitive nature without hearing any sort of evidence on it. So the trial court drew some conclusions that, one, in levying the sanction, the trial court imputed a lawsuit that trial counsel filed on behalf of somebody else to the appellant. I mean, she had no control over that. So things like that were just left up in the air for interpretation.
When was your client first aware that a sanction was being sought here in addition to attorney's fees and costs? Did that come with the June 12th TPPA petition, or did that come at a later date?
Well, I believe I believe that it was requested in the prayer for relief when the petition was filed.
So June 12th?
Yes, sir, but prior to that, well, yes, sir, but on June the 2nd, there was a summary judgment that was filed. So there was no safe harbor.
Well, except, I mean, you certainly could have requested the court leave to still voluntarily dismiss at that point.
I think the trial court could have done that. Or the trial counsel could have done that. What the trial counsel did was request leave to conduct some limited discovery.
The court, in its order granting sanctions, said on page 11, plaintiff does not dispute the factors identified by defendant to determine the appropriate sanction amount. Was that an accurate statement of where the parties were at that point?
Well, no, I honestly don't think that the adoption of the Landry's factors, I think, is as good a test as any. What we take issue with is the way they were applied.
Is the amount.
and the amount, because it seemed to be arbitrary in nature. There was no, the factors that were left out would be, of the Landry's factors were the chilling effect that this would have and the financial effect on the sanctioned party. And that would require some sort of evidentiary hearing as to what the financial condition was, at least as far as that factor went. So the trial court sort of just called the appellant a politician and just assumed that they could pay a $100,000 sanction. It seemed to have been arbitrary and just pulled out of thin air at that number. Interestingly enough, the trial court declined to sanction trial counsel and simply sanctioned the appellant. So for those reasons, the trial court's stated reason for levying the sanction was to deter conduct in the future for the appellant, not others similarly situated, but for the appellant. For that reason, we argue that the punitive nature of the sanction violates the defendant's rights under Article 6, Section 14 of the Tennessee Constitution. It was clearly a punitive sanction. It meets every element of a punitive sanction, and so that, and there was no waiver of a jury trial executed by the appellant, and it wasn't remedial in the.
I would have more sympathy to that argument if an evidentiary hearing had been requested. If you're requesting an evidentiary hearing, then yeah, you can assert a right to jury trial. But if you're just proceeding to an argument on sanctions and saying, well, we don't even mention the need to permit evidence, what's the jury to decide?
Well, I think a waiver is required in a normal criminal context. You're vested with that right to the jury trial.
But this is not a criminal action. The sanctions are not a criminal.
Well, to the extent that they become punitive, I think they fall under the protections of Article 6, Section 14, because the sanction was punitive in nature, and so therefore the protections of the jury trial, I think, automatically vest, such as they would in a criminal action.
Well, Tennessee has laws that allow for punitive damages in civil actions, and I've never heard any court say that the protections of a criminal defendant come into play.
Well, and punitive damages, I believe, are of a different category, but those are normally based on some sort of evidentiary hearing or a trial or something like that. This record was all based on pleadings, and as the court's aware, pleadings are not evidence. So it's an arbitrary sanction that I don't think was grounded in law, and it was clearly aimed at the appellant, who the record doesn't reflect that the appellant was ever even at these proceedings. And we cited the Reguly case that this court decided in that regard, that $5,000 sanction in that case was punitive, and that wasn't a criminal case. So Article 6, Section 14 applied in that case.
Did the court say Article 6, Section 14 applied in that case?
In the Reguly versus Anderson, and I cited that in my brief. It was a $5,000 sanction, but it was upheld.
It was a fine, wasn't it?
I don't know if they used the word sanction or fine. I think they used the word sanction in that case. Okay. I apologize. I don't exactly remember that.
I'll look. Thank you.
Yes, sir. But for it to be considered plain error, and I may address this on rebuttal, but we do think that an equivocal rule of law has been breached based on the regularly case. And that would be the article, the $50 fine clause, just for brevity. And that would simultaneously be a substantial right that has been adversely affected. The trial court called trial counsel negligent, so I don't think that it was waived for any tactical reason. I think the record's clear from that, and just consideration of the error is just necessary to do substantial justice, because sanctions such as these would just have a massive chilling effect on anybody that would ever file a suit such as this.
Well, I think that's the point here, is they wanted to deter a suit such as this because it violates the TPPA.
Well, and the merits of the suit, I mean, when you get in and this, the Supreme Court just, some of the conduct that was considered in the sanction was that the appellant was represented in another case that had been non-suited. And the Tennessee Supreme Court not only just upheld this court that a non-suit leaves a TPPA petitioner without the award of attorney's fees or sanctions or anything like that. So for the Tennessee Supreme Court to rule that way, and it just came out a week ago, and I believe it is
Flayed, yes.
Flayed.
Yes, sir. So that being the punitive conduct, our Supreme Court has said not only, I mean, they didn't address whether it was punitive or not, but it's certainly, if it's considered non-suit as a matter of right is still preserved, then it shouldn't be held punitive against the client, against the appellant here for doing that. And it certainly shouldn't be imputed from her trial counsel who had filed on behalf of somebody else. So for those reasons, we think the fine should be vacated, and I'll yield my.
Thank you, Mr. Spratt. We'll hear from you on rebuttal. Mr. Horwitz, good afternoon.
Good afternoon, Your Honors. Daniel Horwitz, the Nashville Bar, on behalf of Mr. Rosenberg. Ms. Foreman has raised 3 issues in this appeal, but all of them are waived and none of them has merit. For those reasons, this court should affirm. Ms. Foreman's first claim on appeal is that the trial court erred in awarding sanctions, but her briefing on this point is unintelligible, so the argument is waived. To the extent that she does develop an argument, it appears to be something along the lines of a claim that Rule 11's safe harbor standard should have been applied here. That argument was never raised below, so it's waived for that reason as well. On its merits, the argument is also wrong. Rule 11 in Tennessee Code Annotated Section 20-17-107A2 are different provisions. This court must interpret the TPPA's sanctions provision in a way that does not render it meaningless or superfluous. For that reason, Ms. Foreman's suggestion that the TPPA's sanctions provision is merely duplicative of Rule 11, including procedurally related to the safe harbor provision, is wrong. The trial court also made a specific finding here, repeatedly, that sanctions were necessary to deter Ms. Foreman from repeating her conduct. Such a determination requires a trial court to award sanctions under Tennessee Code Annotated Section 20-17-107A2. The trial court's finding that sanctions were necessary to deter Ms. Foreman from repeating her conduct is also unchallenged by Ms. Foreman in this appeal. So for those reasons, the trial court's order awarding sanctions should be affirmed. Before I move to the amount of sanctions and the analysis regarding it, I do want to address what I just heard from opposing counsel, that there was, quote, never any proof, never any evidence taken. First, as Judge McBrayer noted, trial counsel never requested an evidentiary hearing, and that is the end of the matter under, I believe, your decision from January of this year, the Plofchan versus Huey case. Citation on that is 2024 WL 64164, where the court held that if you don't request an evidentiary hearing, you don't get an evidentiary hearing, and this court has repeatedly affirmed sanctions awards based on documentary evidence alone, which is exactly what we have here. Overwhelming documentary evidence, including statements from Ms. Foreman herself, lawsuits that she had previously filed, statements made about the litigation during the litigation, her loans and her ability to pay, loaning her own campaign over $130,000. There is overwhelming documentary proof in this record, and there are no evidentiary objections raised in this appeal. So certainly they're not in a position to contest any facts, both because they haven't done it and because there are no evidentiary issues raised here. This claim that some other lawsuit filed by trial counsel was imputed to Ms. Foreman, it's simply not true. The trial court sanctions order does not say anything about that. We certainly asked the trial court to sanction not only Ms. Foreman, but also her counsel.
And did that request for sanction come with the initial TPPA petition?
Came twice. So first, yes, it was in the initial TPPA petition, and then there was separate, robust briefing related only to sanctions. And part of the reason why we do it that way is because we do think that the Landry factors the trial court considered were appropriate. That's what we argued below. That's what Ms. Foreman did not dispute below. And based on those factors, there are considerations that relate to the litigation. For instance, how long a litigant maintains it, the degree of bad faith, so how long you prolong the litigation, how your efforts to impose costs on the other side, certainly uncompensated costs like the ones that we have here. So all of this matters. How long you sit in there and make somebody continue to respond.
You mentioned uncompensated cost. I want to ask about that in this case. So this lawsuit had its initial life in Williamson County.
That's right.
And there were fees incurred there, and you're saying that those were not awarded by the trial court here.
That's
because
right.
They were incurred in Williamson County.
Well, not just that they were incurred in Williamson County. The TPPA's attorney's fee shifting provision, while welcome, is not comprehensive. It only applies to fees related to the TPPA petition. So when Ms. Foreman...
And you said you had your summary judgment plus motion to transfer video.
Yeah, I mean, it's 6 months of litigation or so in Williamson County, 2 court orders required to get this case that had nothing to do with Williamson County, between 2 Davidson County residents, one of whom was running for office in Davidson County, suing over a Davidson County newsletter. She goes ahead and files it in Williamson County for no reason that we can gather, other than that she was trying to run up uncompensated expenses, and she succeeded. So yes, to the extent that that happened, all of that is relevant to the ultimate sanctions calculus. So what we did is we said we want sanctions at the outset when we filed our TPPA petition, and then we filed comprehensive briefing related to the amount that we thought.
And that came after the July 11th. That was like July 23rd. Or
after
whatever.
the grant, which we thought was going to be the end of the case, but then Ms. Foreman goes and tries to restart the case anew, files a 5402 motion to do this all again, ropes in the Attorney General, requires a new round of briefing, new orders. I mean, this case would not die under her version of events.
And so the Landry factors here, looking at Texas equivalent of Rule 11, that suggested? I mean, I read the sanctions order, of course, and the court suggested they've done their own research. But is that something that the parties knew going into this final hearing? We're going to be looking at Landry as the model.
That's what we briefed. It's a bunch of non-exhaustive factors, all of which we think are appropriate. I briefed them all. We also offered some additional factors that I thought were appropriate for the trial court to consider. Trial court did not agree with me, but I'll just highlight one of them. The amount that a plaintiff puts in controversy, I think, is an extremely important consideration when it comes to the ultimate sanctions amount. Here, Ms. Foreman asked for not less than $300,000 in compensatory plus punitive damages, plus a speech-based prior restraint. That is the amount that she placed in controversy here, and I do think that the amount that they attempt to gain as part of the litigation is an extremely important consideration. Trial court happened not to agree with me, but these factors are non-exhaustive. Trial court made about a dozen factual findings related to the factors that it did think were appropriate to consider.
Now, in Texas, they would say other elements are more important in setting the amount. And they would say, let's look at the nexus between the improper contact, the offender, and the sanction imposed. And then secondly, they would look at less severe sanctions and the amount of attorney's fees that were involved. So they would look at it differently. And you're suggesting we should, and I appreciate that's concurrence in Landry, not the main opinion you're saying we should look at it differently than that?
I don't think you should look at it differently. I think these are non-exhaustive factors. You're not, looking to check every box, and it's an overall calculus of just how bad was this lawsuit? How long did the plaintiff drag it out? What is the level of bad faith involved? But I think the most important consideration, it's the one that comes out of Landry, it came out here, is has the plaintiff done this before, and do they exhibit some indication that they will do it again? The answer here is yes. Ms. Foreman was unrelenting in abusing the legal process against her critics during her campaign for elected office. If you were to try to create in a laboratory, right, a SLAPP suit that was more quintessential, or the platonic ideal of SLAPP litigation, you would have a hard time coming up with an example that is more suggestive.
The platonic ideal of a SLAPP suit. Okay.
How do we address Mr. Spratt's argument that this is a punishment and it violates the defendant's right under constitutional grounds?
Quickly, not only as waived, but also as wrong. I do want to talk about regularly, where you asked what they said, what you all said there. I have the quote. She was ordered to pay a penalty to the Chancery Court of Williamson County, Tennessee, in the total amount of $5,000. The reason that matters is because, hold on, let me get the citation here. This is from City of Chattanooga versus Davis, Tennessee Supreme Court, where they talk about what is implicated by the $50 fine clause, and this is what the Tennessee Supreme Court had to say. Quote, as this court has acknowledged for nearly a century, the restriction on imposing fines contained in Article 6, Section 14, does not prevent a court from imposing any monetary assessment in excess of $50, and here's the key. At the time that the 1796 Constitution was drafted and ratified, the term fine was understood to mean a payment to a sovereign as punishment for some offense. Payment to a sovereign as punishment for some offense. Mr. Rosenberg is not a sovereign. Definitionally, the assessment levied against Ms. Foreman here is not a fine, nor is the assessment punitive, by the way. Its explicit purpose is to deter future misconduct, not to punish past misconduct. But regardless, you don't need to touch this constitutional argument. This was not raised below. Stated up front in his brief that this is presented for the first time on appeal. Ms. Foreman has asked for plain error review, which is exclusively a criminal doctrine that does not apply here, so you can just dismiss it as waived, especially because Tennessee Supreme Court has repeatedly said that if you can resolve cases on non-constitutional grounds, you should do so. Here, waiver is an easy non-constitutional issue that resolves the claim, so it should be rejected.
So going back to the nexus factor here, and I know that below, so you're sort of in a difficult position here in the sense that you ask for the attorney to also be sanctioned as well, and the court declined that. But what proof do we have that we can direct all that at Ms. Foreman as opposed to counsel?
Ms. Foreman filed at least 3, in her name, I'm not talking about her counsel, she was the plaintiff in repeated instances of SLAPP litigation, including against her actual opponent at the time that she was running, which she, again, ran up as long as possible, and then 30 minutes before the hearing on her TPPA petition, non-suited it, laughs all the way out of the courtroom because she doesn't have to pay fees now, and then pledges to refile the thing. I mean, that is her as the plaintiff, and it's certainly her agent, right, carrying out her interests as a party. But beyond that, I mean, the statements that she was making regarding this litigation and regarding her general, what she considered, what I'm referring to here is a Facebook post that she says after this TPPA petition gets granted, where people have to sue to protect their reputations now, it's worth every penny. I mean, she is looking at this and saying, this is worth the money to me. I can abuse my critics, punish them by filing defamation lawsuits all over town against anyone who criticizes me, including my opponent, including citizen critics, including people who are supporting my opponent. She was using the legal process in exactly the way the TPPA is designed to deter. I think the trial court was extremely reserved in the sanctions amount here. I hope that this will be enough to deter her future misconduct. We think that the record and the evidence in the record, which is robust and unchallenged, would have supported a much higher sanctions amount, but the trial court disagreed with me. If anyone's aggrieved here, it's us.
In all the comments that Ms. Foreman made came after the award of attorney's fees here?
Yeah, so I guess it depends what you mean by after the award. So yes.
So I'm talking about, your initial reaction, I feel like, should be in a TPPA successful suit is award of attorney's fees are not enough, because the statute seems to be set up that way, right? It's you shall award attorney's fees, and then you may award sanctions. I'm coming in, let me just tell you theoretically how I'm looking at these cases. My presumption is the award of attorney's fees is enough in most instances, but you can have other indicia that it's not enough, that they make, like you're pointing out here, that they've made statements and said ha 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 or whatever. And so I guess what I want to know, was there a record established here that those, I don't care about the attorney's fees, came after the award of attorney's fees?
Yes, including trying to restart this litigation anew after the attorney's fees award. I do want to push back on one issue about fees are mandatory, sanctions are discretionary. The way that I read the statute is if the trial court makes the determination that sanctions are necessary to deter repetition of the conduct by the party who brought the legal action or by others similarly situated, if the court makes the finding, sanctions are necessary to deter repetition of this conduct, then the award of sanctions becomes mandatory. And
but in that instance, though, sanctions could mean other things, right? It doesn't have to mean a monetary sanction.
That's true. I think the availability of relief is broad here, but under the circumstances presented, I mean, we've got 12 fact findings, none of which are challenged on this appeal, about her filing similar actions, about her acting frivolously and in bad faith. She has a law degree. She was a politician. She's claiming that her ability to pay was not considered. We put up a bunch of evidence related to her ability to pay, and she didn't respond to it. Now she comes up on appeal. We're still arguing about something that she has no chance of winning, when it's her fault for not getting whatever evidence she wanted into the record here.
And in your view, in the first instance, then, does the petitioner, the TPPA petitioner, have the burden then to present proof on the factors that they think is important?
I think so, yeah.
And so, we're looking at, and in this case, it was documentary proof, but plus affidavits as well.
I don't say plus affidavits. I don't think that's right. But it was largely documentary proof of Ms. Foreman's own lawsuits and statements.
Yeah, okay.
Trial court's judgment should be affirmed. I think the trial court was extremely reserved here. Ms. Foreman was a menace, and the record could have supported a much larger sanctions award. The court did not abuse its discretion in applying a smaller one. Thank you.
Thank you, Mr. Horowitz. Mr. Spratt, you've got 3 minutes for rebuttal.
Thank you, sir. And I take issue with several things that Mr. Horowitz just said. First off, he characterized social media statements that were made after the fact. Those are in the record. He filed those in the record. Ms. Foreman was mentioning the Trevor Bauer lawsuit. So this is the exact kind of stuff that was not questioned at the trial court, that was just blessed and said, let's pluck a $100,000 monetary sanction against her out of thin air. And that's how this case was handled. You learn in law school.
But it wasn't the responsibility of trial counsel then to say, look, Your Honor, you need to look at these statements they're relying on in context, and the context is different than what they're claiming it to be. And if without that, how can we fault the trial court for accepting it? There has to be, to get at the truth, we've got to have both sides engaged in challenging what's presented. And what I hear here is that, well, they presented this and we felt like it was not enough, and appellate court look at the context now. The context has to be looked at the court below, doesn't it?
Well, I would agree, Your Honor. The one thing that trial counsel did do was ask for the state to do limited discovery, including depositions, which would have gathered some sworn testimony. At a bare minimum, it would have gathered some sworn testimony. As far as the Williamson County delay that was considered, I'd like to move on to that. It is in the record that Mr. Rosenberg's counsel, in a motion, said that it is not necessary to seek delay, or to seek dismissal, I'm sorry. So they had the chance to seek dismissal and expressly avoided that in Williamson County. It's clear from the record that this was pulled back up to Davidson County with a summary judgment motion waiting. So they were willing participants in this. I also think it's clear from the record that Mr.
Wait,
Rosenberg.
you're saying that, I mean, I'm sorry. A defendant in a defamation is a willing participant in the case.
I
That's what
believe
you're
in this-
telling this court.
I am, Your Honor, and I believe it's in the record that there was a contingency fee for a defendant in this case, which I've never seen nor couldn't fathom how that could be structured. But that's what the record would show. They had the opportunity for dismissal, expressly waived dismissal in Williamson County. And as soon as the record was transmitted to Davidson County, there was a summary judgment motion waiting first. And so to say that she delayed that, it's also in the record that counsel in Williamson County for Mr. Rosenberg added some language that apparently Ms. Foreman's trial counsel didn't allow. And Ms. Foreman's trial counsel, not present at that hearing, then requested that that motion be modified, which caused the delay. That's not the fault of Ms. Foreman. So some of these things that the trial counsel considered. Now also, finally, I believe it is in the trial court's order that the suit that did not involve Ms. Foreman was considered in there. So I don't think that was represented correctly to the court.
All right, thank you, Mr. Spratt and Mr. Horowitz, for your arguments. We'll take the case under advisement. Call the next case, please.
Dina Brow versus Denise Thomas,